If you're involved in hiring, managing, or supervising employees, no doubt you're somewhat familiar with the employment provisions of the Americans with Disabilities Act, the ADA. You may know that the Act was originally signed into law in 1990 with the intent of prohibiting discrimination against people with disabilities. Like many laws with far-reaching effects on employment and other aspects of economic life, the Act has been subject to a number of legal actions, some of which have resulted in rulings that Congress later determined were not in keeping with the law's original intent. So, in 2008, Congress enacted the Americans with Disabilities Act Amendment Act, the ADA-AA. The rules implementing this law became effective in 2011. And it's important to understand how these rules and the overall law affect your workplace. In this program, we'll review some of the key elements of the law, give some examples of how the rules are to be applied, and demonstrate how a supervisor and an employee work together to find a reasonable accommodation. Finally, we'll discuss the actions you can take to ensure that your organization is in compliance. When the ADA-AA was passed, Congress directed the Equal Employment Opportunity Commission, the EEOC, to amend its regulations to reflect the changes from the earlier law. So, we'll also concentrate on how the EEOC's regulations apply to employers and their agents, that is, managers and supervisors. Let's begin by considering this question. To which employers does ADA apply? The law generally applies to employers with 15 or more employees. In addition to protecting the employees of these employers, the regulations also protect job applicants. However, you should know that state and local regulations regarding the treatment of people with disabilities may apply to smaller employers. The ADA uses a three-pronged approach to defining an individual with a disability. The three prongs can be summarized as individuals having a current condition, individuals with a record of having a condition, and individuals who are regarded as having a condition. Let's spend some time discussing each prong. Prong 1 defines an individual with a disability as one who has a physical or mental impairment that's substantial. What about the second prong, individuals with a record of having a condition? This prong of the definition of disability is designed to protect individuals who may not currently be experiencing the effects of an impairment, but who have a record or history of a physical or mental impairment that substantially limited a major life activity. An example of an individual who fits this prong of the definition is someone who has recovered from cancer or who is in remission but who believes their employer is denying them a promotion because they once had the disease. The third prong of the definition relates to individuals who are regarded as having a disability. This prong demonstrates the regulation's emphasis on discrimination rather than demonstrated disability and comes into play even when the individual does not currently have a substantially limiting impairment or a record of one, as required under prongs 1 and 2. What about mitigating measures? That is, measures that reduce the effects of an employee's impairment, such as hearing aids or medications. With one exception, determining whether an impairment substantially limits a major life activity must be made without regard to the effects of mitigating measures. When an individual meets any criteria of the three-pronged definition, two other key concepts come into play: essential functions and reasonable accommodation. Under ADA, an individual with a disability must still be qualified for a job. What does this mean to employers in the real world? It means you better have detailed job descriptions for every position, with clearly stated, legitimate requirements for skills, duties, education, and experience. You should also know that employers do not have to provide accommodations that would cause the employer an undue hardship, meaning significant expense or difficulty. And it's equally important to understand that businesses do not have to hire or provide a particular accommodation to an employee who poses a direct threat. Now, let's look at how the law works in real workplace situations. In order for the reasonable accommodations provisions of the law to come into play in the workplace, an applicant or an employee must make a request for consideration, or the need must be obvious. In our example, when the applicant, or an employee for that matter, requests an accommodation, the employer has the right to ask for reasonable evidence that the individual making the request is indeed impaired. The employer must work with the individual employee or applicant to find an accommodation that works for both. These accommodations can include job restructuring, providing leave, modifying the work schedule, as we saw in our example, and reassignment to other jobs within the organization, or a combination. What you are required to do is make a good faith effort to find a reasonable accommodation by working interactively with the individual applicant or employee. Protection under ADA is not available to individuals who are currently illegally using drugs. If an employer has evidence that an employee or applicant is currently illegally using drugs, any action by the employer based on that evidence does not fall under the ADA. So, how do you help ensure that you and your organization are in compliance with the ADA? Participating in this training program is a good first step. It demonstrates your commitment to understanding and complying with the requirements. If a claim is made against you, your documented participation in ongoing training shows that you have been proactive in learning about the law. And 3, determine whether a reasonable accommodation is called for. Making these 3 determinations will help you decide how to proceed to the next steps. The key points you should understand include the 3-pronged definition of an individual with a disability, the concept of essential functions, and the meaning of reasonable accommodation. Ultimately, you should understand that you may always hire, train, and promote the best, most qualified individuals. What the law seeks to prevent is discriminating against individuals who are otherwise qualified but have a disability. If you have questions about a specific situation, your best approach is to apply the information you've learned by watching this program and to seek the help of your human resources personnel with specific knowledge of the law.